I wanted to be, to come to Nalsar for a long time, and that's because of your alumni. And I must say that, a college really is, its quality is demonstrated by its alumni. And I've been very fortunate to have been instructed as well as assisted by many of your alumni. Mehfooz Nazki of the 2007 batch was my chamber junior for a few months. Then you have a wonderful lawyer in Dr. Amit George, who is, does a lot of arbitration work with us, as well as in the high courts in Delhi. And Divakar Maheshwari, who is a partner in Khaitan, and I have the good fortune of being instructed by him very often. And absolutely outstanding quality, and I see in all of you, hopefully, future star litigators. And thank you again for coming this morning. Now, why did I choose extradition as a topic to discuss? It is a niche area. It's an area that none of you will ever specialize in full-time, unlike in England where many lawyers and QCs actually practice extradition full-time because of the nature of extradition practice in India. But I believe it's an extremely important area, an area which is critical not only for the growth of criminal law, but for the growth of the rule of law in the world as it stands today. We are today in a world, as you know, which on one hand is full of Islamic militancy, as they call it, and on one hand is full of Trump kind of administration. We are in a world with two groups of mavericks, if I may say so, and the need for a kind of secular outlook through the rule of law is critical for the growth not only of this country but of the world as well. And when I take you through these various slides on extradition, you will realize how important it is in a difficult time to adhere to the rule of law, and how easy it is to say, yes, that's a terrorist act, hang him. Yes, that's a terrorist act, throw him out. You see, and this is where the true test comes as to whether the rule of law really governs the planet as it should. Extradition, as we understand it today, can be divided into four different concepts. Extradition, which is traditional, which I will deal with in great detail. Deportation, which is really not extradition, but why I will deal with deportation is because there is a lot of overlap in the law between extradition and deportation, at least in concepts. Rendition, which is the American cowboy version of extradition. And collective expulsion, which is something which is greatly inflicting the world, including our own country, when we routinely expel people in the name of being Bangladeshis, Rohingyas, or whatever. I'm first going to give you some traditional definitions, and you will see as I go through this lecture that all this sort of really doesn't have too much significance when you actually deal with the practicalities of law. Extradition is known traditionally as the surrender by one country to another of an individual accused or convicted of an offence outside its own territory and within the territorial jurisdiction of the other, which being competent to try and punish him demands the surrender. This is exactly what extradition is. Deportation, on the other hand, has nothing to do with crime. And deportation is the removal or sending back of an alien to the country from which he came because his presence is deemed to be inconsistent with public welfare. And this is a huge concept, which starts from the meager violation of a visa to several other concepts. Not too relevant for today's topic, but important because it has a huge bearing on how the law of extradition has grown. Now, rendition is important to understand. Rendition, as traditionally understood, is nothing but extradition. So the definition of a rendition is a return of a fugitive to the state in which he is accused of committing a crime, for example by way of extradition. An extraordinary rendition is the extrajudicial transfer of persons from one jurisdiction of a state to another for the purposes of detention and interrogation outside the normal legal system. But rendition is the biggest problem in today's world. And as I will deal with renditions later, you will realize that this is what the Americans use to take people from one jurisdiction to another, completely ignoring the rule of law. Collective expulsion, on the other hand, is a measure of compelling aliens as a group to leave a country, except where such a measure is taken on the basis of a reasonable and objective examination of a particular case of each individual. Now please note that this is prohibited in the EU Charter, it is prohibited by Protocol 4 of the ECHR, it is also prohibited in the draft articles of the ILC. But today the world is facing a refugee influx. The world is facing a huge movement of people from one continent to the other. The world is also facing a belief that these people should not be allowed to have human rights or any kind of protection. Collective expulsion has suddenly become the greatest challenge to international extradition law. So let me begin with extradition, and I have never found any better explanation as to what is the purpose of extradition than in this beautiful part of Kirby's dissenting judgment in Foster. And he says that in a world of increased mobility and interactive technology and new forms of criminality, extradition represents an essential response to the characteristics of contemporary crime. And before we move ahead, this is something I'm sure you have studied already in your criminal law courses. And what are the fundamental principles of extradition? And this goes across any understanding of the law of extradition. One is the principle of double criminality. Now, simply put, you extradite when country A and country B both recognize that particular conduct as a crime. It's not that you can extradite when X country recognizes it a crime and Y doesn't. So that is fundamental to extradition law. But this has been a subject matter of huge debate. How do you come to this conclusion that double criminality is made of? There are two real movements in law as far as double criminality is concerned. First was the judgment in Pinochet. Pinochet, all of you know, you would have studied Pinochet for torture, you must have studied Pinochet for various other things in your criminal law classes. If you hadn't, I would urge you to do so. Now, Pinochet came with the principle that the section or the ingredients must be the same. Take an example of the section 302 of the Indian Penal Code, whether the ingredients of the concept of murder recognized in India would be the same as the concept recognized in the extraditing state. It's a very difficult test. Made extradition very difficult. Then came Carlos Cabal. Carlos Cabal was an Australian extradition of this financial fugitive, as it were, to Mexico. In Cabal, they laid down the test of conduct. Is the conduct similar? Moving away from the concept of is the section similar or the ingredient similar? A much more practical test. In my experience of having appeared both for the Government of India and against the Government of India in extraditions, by and large we bank on the test in Cabal. And by and large I find that more jurisdictions are now adopting Cabal as the test as far as double criminality. The Indian law recognizes double criminality in 2C of the Indian Extradition Act, and so does the UN Model Treaty. Then comes the principle of speciality. Now what is speciality? Speciality, again simply put, is that when a country is extraditing a fugitive, it extradites him saying that you will be tried for A, B, C offense. It is an unwritten convention in the law of extradition that he will not be tried for anything else unless it is a lesser offense. Now we've seen a lot of confusion in Indian law as far as this is concerned. First was the judgment in Daya Singh Lahoria, an extremely good judgment of the Supreme Court which lays down this principle in very plain terms. Then came the highly confusing jurisprudence in Abu Salim. Now Abu Salim, as you know, was extradited from Portugal. Extradited for certain offences under the TADA as well as under the Penal Code. The speciality certificate made it extremely clear as to what the sentences were. But the Supreme Court in Abu Salim 1, which is 2011, 11 SEC 214, said no. The Indian authorities, that is the CBI, who wanted to try and for further offences under section 4 etc. of the TADA, which were co-equal offences in terms of imprisonment, could do so. Charges were framed. Supreme Court of India said absolutely fine. Abu Salim's lawyers moved the Portugal Supreme Court, who said, what is this? Does the Indian Supreme Court not recognize the Committee of Nations? CBI came running back to the Supreme Court and said, no, we'll withdraw those charges. The Supreme Court in Abu Salim 2 in 2013 allows the CBI to do so. But strangely, the Supreme Court decided that, listen, the law laid down in Abu Salim 1 continues to be law under 141. In my respectful view, it is wholly and completely wrong. Completely contrary to the basic understanding of the law of extradition. And that is why I believe firmly, when the Supreme Court brought out its compilation of articles when it completed its 50th year, they very correctly called it supreme but not infallible. I do hope the Supreme Court realizes its folly and realizes that the rest of the world is looking at this judgment saying this is contrary to fundamental principles. Then comes Om Prakash Srivastava. This was a new topic. This is a gentleman called Babu Srivastava, extradited from the UAE, came back to India and committed further crimes from jail. So Babu Srivastava, running an extortion racket from Tihar, said, see, I was extradited on a specialty certificate, you can't try me for anything else. Very correctly, the Delhi High Court said nothing doing, because that had nothing to do with what you were extradited for. This is a totally new offence. Section 21 of the Indian Extradition Act as well as the Article 14 of the UN Model Treaty also recognizes these principles, but these principles in any event are absolutely fundamental to any extradition, and whenever you go out and ever do an extradition, you will remember that your fundamental theme in drafting an extradition request or defending one or opposing one will be based on these other principles. Very quickly to run you through the Indian Extradition Act, a wholly archaic statute, and I've been, whichever forum I'm able to speak on extradition, I've been saying that this needs a real overhaul, and an overhaul in the sense it creates problems in reciprocity because of the nature of this act, but I don't think Parliament has the time for such things. It recognizes the concept of double criminality, it recognizes the concept of speciality, it recognizes the concept of political exception, which I'll deal with in some detail a little later. It excludes death penalty, and this is important because 34C provides that if the extraditing country, for example Portugal, does not have the death penalty, then India will not inflict the death penalty on that fugitive. Section 7 is the procedural one in respect of the powers of a magistrate, and Section 8 is of course the power of the central government. And remember one thing, and that's why it's important to know that the power of government is also always important in an extradition. Because extradition is that area of law where there is really an intermarriage between law, diplomacy and politics. And there can never be an extradition in the traditional sense which does not recognize these three principles. The UK Extradition Act, on the other hand, which came in 2003, is a wonderful statute. It deals with the traditional bars to extradition. It deals with the human rights exception, requiring, of course, ECHR compliance. I don't know what happens post-Brexit. It deals with the physical or mental condition of the detainee, an excellent movement ahead. It deals with the detailed appellate procedure. and treatments following arrest, fingerprint samples, etc., all issues which become fairly contentious in extradition, and of course dealing with their police powers. Since we have copied many statutes, I would urge the Indian legislature at some stage, rather than worrying themselves too much, just to copy this statute. It's a good statute, put in an Indian context, will also allow us reciprocity. There are the UN model codes on extradition and the model law on extradition, and if any of you have the time, if you look it up, they are interesting statutes. Now what is interesting is what I put in the last bullet point, which is the concept of what whether or to be care, which is embodied in section 15 of the UN model law. Now what does this mean? It means extradite or prosecute. So as a state which has a fugitive staying here, I can exercise this right and say, I will prosecute him rather than sending him back to you. Now I had the privilege of appearing for the government of India in the Varli extradition. The Varli extradition related to a group of individuals who were pedophiles in Goa. Now, a couple of them were German nationals, a couple of them were French, and Varli was British. As far as the French and the Germans, by statute, they had provided this exception. So we could not get them back. Because they said that, we will exercise this and we will prosecute them there, and to my knowledge, nothing has happened. As far as Varli is concerned, on the other hand, we succeed in the extradition to say, yes, he has committed prima facie crimes, but the British court decided he is too old to come back. That again is politics. There is an element of politics, there is an element of racism, there is an element of colonialism in an extradition court's approach. And when I say all this, I am not committing contempt. I don't even intend to. I am saying that this goes into the making of an extradition request or otherwise. And that's something you will realize as you deal with and practice in this area. Now, what are the defenses as a lawyer that you will take when you deal with an extradition request? Because it's not always that you will prosecute. Now, these are the traditional defenses in an extradition. The abuse of process defense, the principle of political exception, torture, which I'm sure you have dealt with the torture convention, death penalty, which really has gone out of the window as far as India is concerned because of 34C. Minimum mandatory sentence, which has become a huge issue in sentencing today. And socio-cultural defenses, which really deal with deportation, but are interesting for you to see. Let me start with abuse of process. Abuse of process has thrown very interesting cases, especially from India. Let's start with McKinnon. Has any of you heard about McKinnon? McKinnon was this great hacker who hacked American ships in the high seas. Missiles started shooting off thanks to McKinnon. So McKinnon is a huge story in itself on extradition, and read it on the internet when you have time. There's a whole movement behind it. So then McKinnon raised this objection saying that when I go back to America, I will not get any, any fair treatment because the FBI has already made statements that they will deal with me in the fastest possible way. But the House of Lords said that, the test is not about the prosecuting agency. The test is of the court. Has the court given you a threat? The answer is no. And therefore, there is no abuse of process and you can be extradited. On the other hand, in Cobb, which is the second judgment, the Canadian judgment, where the trial court had made a statement saying that X is not surrendering before my court, and as and when you bring him to me, I will give him the harshest punishment. So that is a threat by court. That was held to be a clear case of abuse of process. Burnby is an interesting case. in a case of murder, a person was tried thrice, a hung jury thrice, right? In spite of that, the court says, no, it's all right, you can send them back. Well, a lot of issues on this was discussed, but the court believed that in an extradition context, the comity of courts is more important. Then comes the Indian judgments. Nadeem, which is a Gulshan murder case, an old case, where a very interesting thing happened. The British court said that the person who was deposed for either 164 statements, I guess all of you know what a 164 statement is, as well as some of them who are deposed in court, were deposing in their native language, but the transcription was taking place in English. It still happens in our trial courts. I am told that even before I joined the profession, that in trial courts in Delhi at least there used to be two typewriters. One taking down in the vernacular and one taking down in English. Today it doesn't happen. The witness deposes in whichever language and the judge transcribes it into English. Right? In Nadeem they said that is a violation. That is not fair because the true deposition has not come on paper. Extradition denied. Ravi Shankaran, which I happened to appear for the Government of India in the prosecution. We succeeded before the trial judge, but in the appellate court, the British court came out with an absolutely shocking logic, if I may say so, to say that since we had not recorded 164 statements of witnesses and only 161 statements, the extradition is suspended. Now, I'm sure in your criminal law classes, you must have read the judgments which say, when does a prosecutor or a prosecution agency, prosecutors don't get involved at that stage, record a 164 statement? They record it when they are not sure of their witness. This is apart from the fact that, if it's a certain category of crime, you have to do it. But on a normal crime, you would record a 164 statement only if you believe he is going to reside in the box. The British courts don't think so. So in the naval war room case, our expedition was denied. Maninderpal Singh Kohli, on the other hand, was a judgment of the Delhi High Court in the Hana Foster case. Now what happened here was that this was raised by Maninderpal Kohli, saying that look at Nadeem Akhtar Sethi, look at Ravi Shankar, Ravi Shankar hadn't come there, look at the other cases. Look, these guys never give you extradition. They believe that your system law applies Arctic. Now why are you sending me back there? The Delhi High Court, what we may call the colonial hangover, said no, it's fine. They may say whatever they want about us, but we'll send them back. And this has been my continuous problem when I, at least address judges. I tell them, why are you in such a hurry to send them back? Because extradition is all about diplomacy. If they are holding your fugitives, you must hold theirs. You may say that that's an anathema to the legal system, but no. This is an interdisciplinary area. You have to do so. This is another very interesting case, the Surat bomb blast, where I was assisting the Crown Prosecution Service. In this case, there was adequate material on record to say that many witnesses and many accused had said they were tortured. Many of them said that their confessions under TADA was extricated after torture. In spite of this, in this case, the British courts agreed with us to say that no, that's all not okay, this is a case of terrorism, therefore send him back. Fortunately for him, everyone got acquitted by the Supreme Court, so this matter ended, although he went to the European court, etc. But here, although I assisted the prosecution, I was myself surprised, because I have not seen more cogent material to suggest torture. So therefore, it is subject matter dependent, country dependent, person dependent, when you find foreign courts molding international extradition principles to suit their requirements. Now let's deal with the second principle, political exception. Political exception is what is the most traditional defense in as far as extradition is concerned, and which is dead today, right? And I'll show you how. Now it is traditionally explained by saying that one man's freedom fighter is another man's terrorist, right? And this was, in my view correctly, the law applied for many, many years. Then came 9/11, before 9/11 the various PLO attacks, etc., which changed the law completely. Now let's see very quickly what are the judgments which deal with this. One is T, which said that international terrorism must be fought and the vague outlines of political exception are of no help. So Mustil view has been repeatedly followed now by various courts across the world. In Kabal, of course, it was not terrorism related, it was a financial case. Again, they believed that the political exception doctrine should be given away. Now, RB Algeria, a very important judgment, really finished this defense, where the House of Lords says it should be recognized too, and countervailingly, that there may be compelling reasons in favor of extradition rather than the suspect should enjoy an undeserved safe haven from prosecution. Now, when we deal with torture, you will see that this is becoming a problem. On one hand, you are saying political exception. On the other hand, you are really facing issues of where political exception is leading to a situation of torture. Post 9/11, of course, the United Nations Security Council resolutions in fact knocked this out from any consideration and provide an obligation to extradite. Now this is a very interesting judgment, and this, really sums up the post 9/11 change of jurisprudence. Now this judgment was written before 9/11, released after 9/11. So please see Hoffman's postscript. I wrote this speech some 3 months before the recent events in New York and Washington. They are a reminder that in matters of national security, the cost of failure can be high. This seems to me to underline the need for the judicial arm of the government to respect the decisions of the Minister of Crown, and on questions whether the support for terrorist activities in a foreign country constitute a threat to national security. It is not only that the executive has access to special information and expertise in matters, it is also that such decisions where serious potential results to the community require a legitimacy which can be conferred only by entrusting them to persons responsible to the community through the democratic process. Absolutely wrong jurisprudence, I'm sorry to say. The moment the judiciary starts saying that we will go entirely by what the executive says in such matters, it is the death knell to the rule of law. Today, this has become the basic jurisprudence across all countries. Other courts may not write so eloquently, but say the same thing when it comes to issues of terrorism, issues of accusations of terrorism. Now let me deal with torture. Torture is the only area which gives me some, solace. Torture is an area where the law has not been completely thrown in the dustbin. And wherever it has, at least I find courts across the world retrieving it to ensure there is some protection for the human life. Now, the analysis on torture really go on 2 or 3 different areas. One is your extradition request based on evidence obtained by torture? That's one. Second, when you are extradited, would you face evidence which is obtained by torture? 2 totally different things. They may overlap, but they are different. 3, will you be subject to torture as a fugitive who is returned? Again, very important, both in the extradition context and in the deportation context, more importantly in the deportation context. And going through all this, which I will soon with you, remember that Pinochet said torture is jus cogens, and it continues to be. For post 9/11, of course, there was a complete dilution of all these concepts. First in Askarov, where the principle of so fundamental came into torture jurisprudence. What is so fundamental? When there is torture, it's jus cogens, it's out of the window, but no. Now the jurisprudence became, let's test how fundamental is it, how deep can we go. Then came Abu Hamza, which said that the fruits of the poison tree doctrine does not apply. And this whole issue of illegally obtained evidence being admissible in trial. Of course, the Indian law is the same. The Indian law in Puranmal, the Indian law in Malkani also provides that illegally obtained evidence is admissible. Then came RD Algeria, which said that the mere fact that evidence obtained by torture would be used against a fugitive is no reason to retain him in the UK. This was a complete dilution. But fortunately, in Ottoman, which is a wonderful judgment of the European Court, the fundamentals of torture law were restored. This was a Jordanian deportation and was prevented on the basis that he would be subject not only to torture but also to material which are obtained from torture in the trial which he would have to face. And most importantly, that Askarov test was taken away and now the test was reintroduced as real risk of the admission of torture or evidence. Now these were the traditional tests. Soring and Chahal were the absolutely traditional basis on which the European courts decided as to whether an extradition or a deportation should be done. As far as Soring is concerned, it was an extradition of a German national to the United States to face charges of capital murder, and it was disallowed in the light of the real risk of torture. Chahal was an Indian extradition. A person accused of being linked with Khalistani terrorist groups. The Human Rights Commission here gave a guarantee that he will not be tortured, yet the ECTAB said that the moment there is a possibility of him having to face treatment contrary to Article 3, they will not be deported. Lodi and Abid Nazir are similar. Extraditions, one to the United Arab Emirates and the other to Pakistan. But Abid Nazir is a very, very interesting case as far as the law of extradition. Now, the court found that it's not okay for him to go to Pakistan, but they found it's okay to go to the United States. Abid Nazir is again an example of how dangerous this jurisprudence is. Do Western courts believe that it's okay to exploit someone to a Western country but not to Pakistan, knowing full well that the nature of human rights violations are equally bad in both nations? This sets strong precedents. I am not saying for a moment that Abid Nazir should have been extradited to Pakistan, but at the same time he certainly should not have been extradited to the United States. These are the problems in the law of extradition. Now this is a very interesting judgment. Now this judgment of the Grand Chamber is something which makes you feel there is hope. Now here was a deportation from Sweden. A person who was running a transport operation for the US Army, targeted by the Al-Qaeda. He had lost his daughter and he was on their hit list. The Swedish authorities said it's fine to go back. Fortunately, the Grand Chamber that too by a narrow majority, 10-7, decided to hold it. But this is important and it's significant that in the light of what is happening in the Middle East and the problems which it is creating, this kind of jurisprudence is absolutely important. Now, as I've told you that the death penalty defense is a dead defense as far as India is concerned. We have ourselves recognized that if the extraditing country does not have the death penalty, then we would not give the death penalty. So this is really over. It used to be a big issue earlier. But the bigger issue today is minimum mandatory sentences. I'm sure most of you must have in your criminal law course studied the Indian jurisprudence on minimum mandatory sentence. The judgment in Sriharan, the various other judgments which have come thereafter, the judgment in Vishal Yadav, which has dealt with this whole issue of whether minimum mandatory sentences are possible, not possible, whether they're right, wrong, etc. But this becomes important in the context of an extradition as well. And today increasingly is becoming a defense. Now, before I go to minimum mandatory sentence, I want to just deal with Kalfan Sameer's moment. It's a very interesting judgment of the South African Constitutional Court. Interesting for two things. One, the Americans just came, picked up Kalfan Mohammed and went away. Now, in the challenge, the South African Supreme Court said that first of all, you could not have taken him to a country which had the death penalty. Secondly, and very interestingly, the defense of the authorities was that he had consented to go. For which the South African Supreme Court quoted the Indian Supreme Court judgment in Dasheshwarna to say that that was a fundamental right in South African law which could not have been waived. Now, as far as what is known as irreducible life sentences or mandatory life sentences, again the law is here and there, like you will find in most extradition defenses. In Babar Ahmed, the court said that, see, it is not incompatible. A minimum mandatory sentence is fine, will deport it. The per se test of incompatibility was rejected. Right? Now, after Babar Ahmed, what happened? You have the two judgments in Trebelsi and the recent judgment of the Irish courts. Now, in Trebelsi, again an interesting case where there was an injunction to not take Trebelsi out of Belgium. But the Americans came and took him away. They did a soaring assessment. They held that, sorry, you could not have taken him. And the possibility of him facing an irreducible life sentence in America is very much there, and held that it was a wrong extradition. But finally, all he got was 60,000 euros because he had been taken to America. Democh is another interesting judgment. A judgment of the Irish courts relies on Trebelsi and dealt with the American conditions in their jails, dealt with the fact that a de facto life sentence is in violation of fundamental rights, and did not allow an extradition. I would rate this as the most exciting extradition judgment that I have come across in the last couple of years. Now, just very quickly taking you through a few of these deportation defenses, but there's a lot of overlap, so it's interesting. But you get very interesting human scenarios here, which you never get in an extradition. Look at it. A case where the Iranian citizen said that, he was homosexual and declared to be so. So he said, if I go back to Iran, I face death. He said, it's not our problem, they sent him back. In M, the defense was raised that the person was an HIV/AIDS patient and in Uganda did not have health facilities. Again denied. But fortunately in M, which was a very interesting case of a mother and a minor child which documented domestic abuse. Fortunately here, the House of Lords allowed her to stay back on the invoking Article 8 of the ECHR. So, these of course are fact-specific cases, don't lay down any great jurisprudence, but are interesting when you try to understand how courts approach deportation. Well, now we come to the interesting area. The area of rendition. The area which belongs to a certain powerful nation in this world who believe they can do anything beyond the law. That's America. And it runs a superhuman agency called the CIA. Have you heard of the CIA? So the CIA believes it can do anything anywhere in the world for the greater good of you and all of us. So that we are safe. Safe from what? I don't know, but that we are safe. Now, fortunately we have some jurisprudence on this now. El-Mashiri is a very interesting case. German national, Lebanese origin, a rendition operation supported by the state that is handed over to the CIA and taken to a detention facility in Afghanistan. See, what happens in the end of the day is we get some kind of a compensation, but at least it is an important movement in this area of extradition. Al-Mashiri is another interesting case. Polish supported rendition, taken away, tortured, taken to CIA detention facilities, again strongly condemned by the ECHR. I'm going to the last real area of my discussion on this with you, and that is collective expulsions. The collective expulsions are really, in my view, going to be the future of extradition, and that's because of the international refugee influx, the problems in West Asia, the problems which are moving towards the rest of the world, and something which I want all of you to keep in mind as young lawyers in the making, and that is this. In the more trying situations, there is a greater importance for the rule of law. And I do not believe, although I have been a prosecutor for quite a while in my life, that you can say that no situations require a different approach. There is a problem in Kashmir, the AFP Act is required. There is a problem in the Middle East, therefore forget about the rule of law. It does not work that way. People lose faith, and this is what moves people towards extremist organizations. It is important for all of you to remember throughout your careers that there is no substitute to the rule of law. And there is no better example for this than the law of extradition. Now, Hirsi Jama is a case where Somalian and Eritrean migrants traveling from Libya, intercepted at sea by Italian authorities, sent back to Libya. They were a risk in Libya. The European courts have come down and said this is a violation. It's a violation of the Protocol 4. It is a violation of the UN Model Code, the ILC recommendation. But the problem is we are seeing more and more of this. In Georgia versus Russia, it was an interesting case because in fact here Russians had interviewed each one of those Georgian nationals, created a dossier, done all that, yet the European court said it is not allowed. But India also does this. And India does it for the, what I would call the collective expulsion of Bangladeshis. Now I have, as both counsel for the Delhi police at certain stage of my life, as well as from the other side, dealt with this. And found many times that large amount of these expulsions are a waste of time because whoever is expelled is back in a few months. And secondly, there is a lot of overlap between who these people are. Are they really refugees? Are they really from Bangladesh? You know, and I've always found there is no careful analysis, there is no proper documentation, and does raise very serious issues. Of course, the Indian law is that the power of the executive to expel foreigners is absolute. Well, I do not agree with this logic, but that's the law, and that's the law which has been going has been laid down right from 55 Supreme Court and continues till today. But I do find sometimes that courts look at the human angle of it. And courts find a way out. And I was in an interesting case appearing for the prosecution in Aliullah in the Delhi High Court, where we found this very strange situation where the father was allegedly Bangladeshi, although there was no clear determination. The mother was very clearly Indian, although the authorities would not agree. The children, they were young children. Mother deported already once, but was back. Then finally, well, in spite of my opposition, and I think rightly, the division bench said, redo the entire determination. And when we looked at the determination files, they had done nothing. And I think the very fact that the court asked them to redo it ensured that this family stayed back. Very contentious issue in today's days. But I'm not saying that if a person doesn't deserve to be in this country should continue to remain here. That's not the point. The point is whatever you do it in accordance with law, lay down proper procedures, enforce proper protocol. Another very interesting case where I had the privilege of being the amicus for the Delhi High Court, and I just want to leave you with this, is a case of this person who was detained in Jammu and Kashmir under the Foreigners Act, completed his sentence, transferred to the high security wing of the Tihar jail, discovered by the jail visiting judge, nobody knew who he was, from which country he was. He had come into India as a 11-year-old boy. He said he had come from Saudi Arabia. The Saudi diplomatic mission's analysis said he is not from there. But he was possibly a Rohingya who went to Saudi Arabia. There are quite a lot of them who did so and came back. Finally, we got the High Court to force the government for the first time to declare him as a stateless person. So he was declared stateless. He was given a long-term visa. The Delhi High Court then also wanted to lay down guidelines. But unfortunately, as it happens many times in court, the bench changed and the next bench lost interest in the case and just merged it with some other case and it never saw the light of day. But at least it's interesting because here is a person who was declared stateless, he was given a long-term identity certificate, and he was also provided a job so that he could sort of, live his life here. We don't know what happened to him afterwards, although a welfare officer was appointed, etc. But at least I hope the government uses this as a protocol to ensure that people who are stateless, who will land up in this country, do get some kind of identity. Thank you very much. And if you have any